Many people enjoy films and dramatic productions involving court dramas. 12 Angry Men, To Kill a Mockingbird, A Time to Kill, The Exorcism of Emily Rose, JFK, The Nuremberg Trials, Inherit the Wind, The Verdict, and even The Devil's Advocate. And for most, these films and even television shows may paint perceptions about courts and the judicial system. Films like Erin Brockovich, The Rainmaker, and A Civil Action portray evil large company defendants and ruthless attorneys trampling over the rights of the poor small guys, but at least, most often have a happy ending, where the antagonists lose, and the protagonists go on to live happily ever after, and nobody wants to leave the theater crying. Still, some may have seen consciousness awakening films that inspire, in historic dramas like Separate but Equal, about Thurgood Marshall, and the landmark decision of Brown v. Board of Education, or even Amistad, about the slaves who had commandeered a Spanish slave ship, and had landed in America only to face a battle in the courts to decide whether they would be returned to Spain as slave cargo or be permitted to be free. But imagine for a second what would happen if in either one of those instances, involving Reverend Oliver Brown and his daughter, Linda, who wanted to attend a better school, or Sink, who had been taken in bondage from Africa across an ocean to be sold into slavery, if when they went into a court, just like Dred Scott, and an American court had closed that door, barring their entry. Think it couldn't happen? You may be surprised. Some people describe themselves as social justice warriors, some people describe themselves as possessing a passion for justice, and most people hold some conception in their heads regarding what they would believe to be an unjust result, but only about 1.3 million people are actually licensed attorneys, and, believe it or not, only about 1/5 of those are what might be described as litigators, who make their living going to court. However, many persons in traffic court, anywhere between 40 and 90%, depending upon the state, in family court matters, and between 70 and 90% of what may be described as prisoner cases in the federal judicial system, involve unrepresented, or pro se litigants in court, often going up against professional attorneys, and large corporate defendants or government agencies, by themselves, literally a David versus Goliath contest, and, statistically, unrepresented litigants, often opting for this remedy because of financial considerations, and statistically tend to experience more adverse outcomes. And, at least as late as 2020, case studies on the topic suggest that any fears of the floodgates of litigation opening from unrepresented litigants does not appear to be occurring, nor expected in the near future. For instance, in civil cases, according to statistics, cases involving unrepresented plaintiffs are more frequently disposed before trial, the clinically sanitized phrase or euphemism that means that these cases tend to be dismissed before they ever get to trial. Similarly, while the median award amount for plaintiffs in cases where both parties are represented is $92,950, it is only $1,340 for cases with at least one unrepresented litigant. Nor do unrepresented defendants fare well, because trials involving a represented plaintiff and at least one unrepresented defendant result in a median award amount of $78,700. And when unrepresented litigants go head-to-head in court, the median monetary damages awarded only amount to $8,100, suggesting some level or relative deprivation, or disparities in outcomes, tending to be tied to economics, especially for unrepresented litigants. And these variances in outcomes tend, by and large, to impact the perception of fairness in the judicial system, which is supposed to be, even according to the Constitution, a forum to settle controversies, and all persons are supposed to have a right to a day in court, or, to use the legal term, due process, and equal protection under the law, which courts have described as fundamentally an opportunity to be heard, and at a meaningful time in a meaningful manner. Perhaps one of the first problems encountered by unrepresented litigants is not just a lack of confidence, skill and experience, because just like those structural arguments that are often heard in other social issues, a person who arrives in court is an odd man out, not in the club, so to speak, and, although often held at least to the same standard as an attorney, is not even treated like an attorney in the courtroom and when filing pleadings. There are some basic differences that cannot be avoided, like being required to provide a certification that no attorney assistance has been provided, filing what is often called a ghost writing form in many courts, and, in the courtroom, while an attorney can enter the that space between the judge and where the legal counsel sit, an unrepresented litigant is not permitted to announce the call to approach, and enter essentially a private conversation with the judge. But also apparently because of what is described often as the institutional memory of the courts, even the progressive Fourth Circuit has said that for pleadings and complaints filed in court, in the great run of pro se cases, the issues are faintly articulated and often only dimly perceived, or inartfully pleaded, and overcoming the stereotype is not as easy as one might hope. In practice, some courts have even attempted to paint the unrepresented litigant with the stereotype, using words like rambling and a fantastical to describe what have been called enigmatic allegations and mere criticisms contained in prolix complaints, judging the unrepresented litigant not as an individual party in a case, but rather presenting a picture in the order that conforms to the popular perception, and especially in cases where a court decides to go to the extent of imposing an injunction against an unrepresented litigant, they will at least offer the pretext, without specifics, regarding the onerous costs imposed upon the courts and other parties, most often meaning the powerful defendants that these plaintiffs have summoned to courts to seek redress from damages and injuries. While many defendants have gone to the extent of asking the courts to act as the gatekeepers, impugning even a perception of fairness from the start. And, even though the progressive Fourth Circuit has said that there is a greater burden and a correlative greater responsibility upon the district court to ensure that constitutional deprivations are redressed and that justice is done, many unrepresented litigants will often find their cases dismissed in the preliminary stages, giving rise to at least lip service from the Virginia Supreme Court decrying the multiple times when courts have attempted to short-circuit litigation and quash cases brought by these litigants, depriving them of their day in court. However, one unrepresented litigant who has even been described as passionate by President Joe Biden, and as a litigation hobbyist by Attorney General Merrick Garland does not appear to be daunted by the courts or large corporate defendants, and Major Mike Webb has brought cases against large federal agencies including the Merit Systems Protections Board, the Department of Defense, the Centers for Disease Control, the FDA, the Defense Intelligence Agency, the Department of the Army, the Secretary of Defense and even the White House. And, to the extent that for every action there is an equal and opposite reaction, the White House has even recently outsourced to tap James Lyons, a former nominee for a judgeship in the U.S. Circuit Courts of Appeal and author of the Whitewater investigative report to go against him in court. Facebook, or Meta platforms, not only retained representation from Orrick, Harrington and Sutcliffe, an established San Francisco international law firm to defend against Major Mike Webb, but also tapped their rising star partner who specializes in high-profile clients and bet the company litigation. Trained by a legendary civil rights and criminal defense attorney, and has literally been in courtrooms since he was in grammar school, working on high-profile cases. He has worked in major law firms, helping to represent large corporate defendants in complex litigations, and now, Major Mike Webb is in courts fighting every day for normal people, probably like you.
This message was approved by Major Mike Webb. Honest.